Hello, I'm Fariza.
Hi, I'm Ekta.
Hi, I'm Nurin.
Hi, I'm Dina.
Hi, I'm Florence.
And hi, I'm Uttara, and today our group is going to provide a brief on the Donoghue and Stevenson case.
Donoghue and Stevenson is also known as the Paisley snail or snail in the bottle case, which is a very significant case in Western law. The decision fundamentally created a new type of liability in law which did not depend upon any previously recognized category of tortious claims. This was an evolutionary step in the common law for tort and the late, moving from strict liability based upon direct physical contact to a fault-based system which only required injury. In the case of Donoghue and Stevenson, Lord Aitken proposed that the Never principle, which determines when a duty of care may arise. The principle is that one must take reasonable care to avoid acts or omissions that could reasonably be foreseen to likely injure one's neighbor. A neighbor is identified as someone who was so closely and directly affected by the act that one ought to have done in contemplation, which directing one's mind to the acts or omission in question. In this video, we are going to share with you a brief about the Donoghue and Stevenson case and discuss the neighbor principle.
This event took place on the 28th of August 1928 in the Well Meadow Cafe in Paisley, Scotland. The plaintiff, Miss Donoghue's friend, had ordered a ginger beer for her which was contained in an opaque bottle. She had already consumed half of the drink before discovering that there was a decomposing snail when she poured the remainder of the drink into a tumbler. Upon seeing the snail, Miss Donoghue suffered shock and complained of stomach pain. She was then diagnosed by her physician of severe gastroenteritis. As she was not the one who had ordered the drink, she could not bring an action for breach of contract against the cafe owner. She instead decided to sue the manufacturer, Mr. Stevenson, for the tort of negligence.
Now that we understand the facts of the case, let's move on to the issues. The first issue was if Mrs. Donoghue was able to sue the cafe owner. It was determined that Mrs. Donoghue was not able to sue the cafe because she was not the one who ordered the drink. This meant that there was an absence of contract between her and the cafe owner. Since Mrs. Donoghue was not able to sue the cafe owner, the next key issue was that the House of Lords tackled was if the manufacturer owed Mrs. Donoghue a duty of care in the absence of a contractual relationship.
Thank you, Noreen, for the facts and the issues of the case. We will now move on to what was held by the court. Firstly, Lord Aitken, in his own word, "Who then in law is my neighbour?" To which he replied, "Persons who closely and directly affected by my acts or omissions that I ought reasonably to have them in contemplation as being so affected when directing my mind to the acts or omissions that are called in question." In summary, Lord Aitken states that one must take reasonable care to avoid acts or omissions which one can reasonably foresee would be likely to injure the person who are closely and directly affected by one's act. Secondly, Lord Macmillan stated the liability of manufacturers to consumers. In his dictum, he states that a manufacturer owes a duty of care to those who intend to consume his products. Since he is manufacturing products for consumption, he places himself in a relationship with all potential consumers of his commodities. Therefore, he must take care to avoid injury to its all potential consumers of his product. Lastly, Lord Buckmaster was a dissenting judge in this case. He argued that the general rule was that there was no duty of care owed to a third party outside of a direct contract. He implied that it would not be socially or economically acceptable for manufacturing businesses to be open to claims from such a wide group of people if a duty was imposed.
Thank you, Dina, for explaining what was held by the court. Now I am going to explain the three important outcomes of Donoghue and Stevenson. Firstly, negligence. The House of Lords ruling affirmed that negligence is a tort. A plaintiff can take civil action against a respondent if the respondent negligence caused the plaintiff injury or loss of property. Since Donoghue had not purchased the drink, she could not prove contractual arrangement with the cafe owner. Even though the relationship between Donoghue and Stevenson seemed distant, Lord Atkin's judgment established that Stevenson was still responsible for the integrity of his product. So secondly, the duty of care. It gave an immediate importance to impose a duty of care, especially to manufacturers in respect to the production of goods. For example, products that cannot be inspected before consumption by the consumer. According to Lord Atkin's ratio decidendi, a manufacturer of products which he sells to reach the ultimate consumer in the form in which they left him owes a duty to the consumer to take reasonable care. This precedent has evolved and now forms the basis of laws that protects consumers from contaminated or faulty goods. Thirdly, the neighbor principle, which extends the tort of negligence beyond the tortfeasor and the immediate party. It raised the question of exactly which people might be affected by negligent actions.
The principles stated in the case of Donoghue and Stevenson have been universally recognized to be authoritative in England as well as Scotland. This was gradually used to cover more and more situations where liability did not lie in the common law. The decision made in this case may be regarded as a milestone, and the well-known passage in Lord Atkin's speech should be regarded as a statement of principle. Lord Atkin, in his famous statement of the neighbour principle, states that a neighbour is persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to acts or omissions which are called in question. The neighbour principle is part of the ratio decidendi of Lord Atkin's judgment. This principle is adopted in admitting a new duty into the law, that the duty itself must be phrased in terms of reasonable foreseeability. A good example where the neighbour principle was used to create a new duty and to delimit is Powlett and University of Alberta, in which the Board of Governors were held liable to the plaintiff. Duties of care are owed, not only to physical neighbours but to anyone who is my neighbour in the wider sense. The scope of the duty has been extended to include repairers, assemblers and erectors, and that is not confined to articles of food or drink. The benefits are reciprocal in that the occupier, as well as having the duties, enjoys the rights which are correlative to similar duties resting on his neighbours. What Lord Atkin was probably trying to do in this judgment was to do away or move away from the situation by situation approach to duty of care and to establish a more general approach that he could apply to all situations. Although this principle can be seen as very, very significant, the overall significance of the neighbour principle has been overemphasized by both its supporters and its opponents. It was not intended to be and cannot probably be treated as being a general formula which will explain all conceivable cases of negligence. The cases of Dutton and Bognor Regis Urban District Council and Anne's Merton London Borough Council, however, pose a far more serious problem in regard to the breadth and extent of the neighbour principle in regards to the case of Donoghue and Stevenson.
Thank you, Actor, for explaining the significance of the neighborhood principle. The principle is used to determine if there is a duty of care owed by one person who is the defendant to another who is the claimant. In detail, it examines whether the claimant is a neighbor to the defendant because those one must take responsible care to not incur harm on those who can be affected by our actions, or simply put, our neighbors.
Thank you, Noreen, so much for explaining how the neighbor principle has been used thus far. Next, we will be moving on to how the neighbor principle has been used in other cases. Now, firstly, there are many cases in which the neighbor principle has been applied. Firstly, the Home Office and Dorset Yard case was a major case to apply the principle. Utilizing the neighbor principle, the officers prima facie owed a duty of care to the owners of the yard, which was damaged by the boisterous boys, which was under the officer's supervision. In the case, Lord Reed confirmed the importance of the neighbor principle by stating that the principle ought to apply unless there is some justifications or valid explanation to exclude the principle. Next, Stanton, in his book, The Modern Law of Thought, states that the neighbor principle finds its foundation in a moralist point of view. What it essentially means is that a neighbor is morally obliged to look after his next door neighbor because they are so closely related. In modern times, the principle has expanded to include liability for economic losses. This is evident in the English case, Lennon versus Commissioner of Police of the Metropolis, where in the case, on transferring to a different police force, the plaintiff was assured by the defendant that he would not lose his entitlement to housing allowance if he were to take time off before the transfer. When the plaintiff's service under the police force of the defendant ceased, the plaintiff took what he thought was to be unpaid leave. However, it turned out to be a break in his continuity of service, hence losing his entitlement to the housing loan. The court held that the defendant owed the plaintiff a duty of care for the economic losses that occurred. The case enforces Lord Atkin's neighbor principle in the tort of economic loss. Not only this, it exemplifies that an employer and employee relationship is akin to being neighbors. Now, on the other hand, the principle is not always in favor of the claimant or plaintiff and has been used to establish when there is no duty of care. In the case of Burhill and Young, the claimant sought to recover for nervous shock when she witnessed the death of the defendant. At the time, the claimant was pregnant and the nervous shock affected the child. The court held that she could not recover for damages because the defendant owed no duty of care to her due to a lack of foreseeability. Now, the case exemplifies essentially that the neighbor principle can be used to protect the defendant from claims of duty of care. These cases illustrate how the neighbor principle has been utilized thus far in case law. Thank you.
In a nutshell, the case of Donoghue and Stevenson has established several important principles, which are first, the recognition of negligence as a distinct tort. Second, the recognition of liability in situations where there is no contractual relationship between the defendant and the claimant. Third, the establishment of a duty of care owned by manufacturers to consumers. And most importantly, the last one, the neighbor principle. It is argued that the neighbor principle has provided a good conceptual starting point for the law in this field and remains the foundation of the law on the duty of care. Even though over the years, the neighbor principle has been added to and refined by the courts, The case has had a lasting effect. The Neighbor Principle changed the law of tort forever, in particular the laws on negligence. Thank you.